Hello everyone. We'll be working on covering Florida-specific laws for those of you who have come forth to me and asked about how to start auditing. We'll be discussing the basics for understanding the common laws that law enforcement will cite when attempting to discourage public photography. Now, as a disclaimer, I am not a lawyer and I'm not offering legal advice. It is still recommended to double check the laws for yourself and seek legal counsel if you need a better understanding of the law. This video is for educational purposes and serves to give you a brief explanation of the law and how it is written. In this video, we will be covering the Florida Stop-and-Frisk law, Florida's Loitering Laws, Supreme Court decisions that uphold your First Amendment right to record public officials in the course of their duties, the Department of Homeland Security Operational Readiness Manual that provides insight on filming government buildings and installations, and which U.S. title codes protect you in the event you are deprived of your civil rights. The first section will be on the Florida Stop-and-Frisk law, also known as Florida Statute 901.151. It is almost guaranteed that during any interaction with a law enforcement officer, they will ask you for your identification. This law clearly defines whether or not a law enforcement officer has the legal right to identify you. Now, whether or not you are required to identify yourself is entirely dependent on what the statute lays out. Section 1. This section may be known and cited as the Florida Stop-and-Frisk law. Section 2. Whenever any law enforcement officer of this state encounters any person under circumstances which reasonably indicate that such person has committed, is committing, or is about to commit a violation of the criminal laws of the state or the criminal ordinances of any municipality or county, the officer may temporarily detain such person for the purpose of ascertaining the identity of the person temporarily detained and the circumstances surrounding the person's presence abroad, which led the officer to believe that the person has committed, was committing, or about to commit a criminal offense. According to this section, a law enforcement officer must have reasonable indication that you have committed, are committing, or about to commit a violation of a city ordinance or a violation of a criminal law defined by the state of Florida. Section 3. No person shall be temporarily detained under the provision of subsection 2 longer than is reasonably necessary to effect the purposes of that subsection. Such temporary detention shall not extend beyond the place where it was first effected or the immediate vicinity thereof. This section states that a law enforcement officer cannot detain you longer than a reasonable time to determine what you are doing. It generally helps to let an officer know that you were just filming in public and that it is a constitutionally protected activity. That being said, always make sure you are in an area you are legally allowed to be in. If there are signs posted that say no trespassing or restricted area, it's best to stay away from those areas. It also helps to stay in publicly accessible places such as a sidewalk or public easement. Doing these helps shorten the allowable time a law enforcement officer has to temporarily detain you. Section 4. If at any time after the onset of the temporary detention authorized by subsection 2, probable cause for arrest of person shall appear, the person shall be arrested. If, after an inquiry into the circumstances which prompted the temporary detention, no probable cause for the arrest of the person shall appear, the person shall be released. This section states that if you are guilty of committing a criminal offense such as trespassing, law enforcement officers do have the right to identify you, and you could be subject to arrest. If you are not committing a criminal offense, then the law enforcement officer is required to let you go. Section 5. Whenever any law enforcement officer authorized to detain temporarily any person under the provisions of subsection 2 has probable cause to believe that any person whom the officer has temporarily detained or is about to detain temporarily is armed with a dangerous weapon and therefore offers a threat to the safety of the officer or any other person, the officer may search such person, so temporarily detained, only to the extent necessary to disclose, and for the purpose of disclosing, the presence of such weapon. If such a search discloses such a weapon or any evidence of a criminal offense, it may be seized. This section states that if a law enforcement officer has reason to believe that you may be in possession of a weapon, such as a firearm or a knife, they can legally subject you to a pat-down. This does not give them permission to enter into your pockets during the pat-down unless they have reasonable belief that during the frisk, they feel something that could be construed as a weapon. If you do have a weapon on you and you are going to be frisked, it is wise to let the law enforcement officer know about the weapon to ensure your safety. Do not ever reach for a weapon unless you are instructed to do so. Doing so could result in serious injury or even death. The law enforcement officer does have the right to temporarily remove your weapon during a frisk, but does not have the legal right to run the serial number unless you are committing a criminal infraction. It is best to let the law enforcement officer know, quote, I am lawfully carrying a weapon, but I do not consent to search or seizure of my property. This phrase could help you in court if your civil rights are violated. Section 6. No evidence seized by a law enforcement officer in any search under this section shall be admissible against any person in any court of the state or political subdivision thereof unless the search, which disclosed its existence, was authorized by and conducted in compliance with the provisions of subsections 2 through 5. This section basically states that if a law enforcement officer does not follow the proper procedures laid out by the Florida statute, that any and all evidence seized during the encounter cannot be used against you in a court of law. Let's use this as an example. You are on a public sidewalk, walking down the street at 3 in the morning, and you are stopped by a law enforcement officer who states that you're a suspicious person. If they cannot provide clear indication that you've committed a criminal infraction and decide to pat you down and find an illegal substance, such as marijuana, on your person, the evidence cannot be used against you since they violated the second section of the statute. Make sure to have a clear understanding of this statute in order to help ensure your civil rights are protected. And while I don't condone giving up any unnecessary information to law enforcement, certain situations could work out better based on what information you are willing to give. Use your own discretion when delving out your personal information when dealing with an encounter with law enforcement. Another common accusation from law enforcement when out in public is a criminal infraction of loitering. This law is known as Florida Statute 856.021, Loitering and Prowling. Section 1. It is unlawful for any person to loiter or prowl in a place at a time or in a manner not usual for law-abiding individuals under circumstances that warrant a justifiable and reasonable alarm or immediate concern for the safety of persons or property in the vicinity. Now, the main portion to notate in this section is where it states a warranted, justifiable, and reasonable alarm or immediate concern for the safety of persons or property in the vicinity. This portion is usually ignored by law enforcement officers when they attempt to accuse someone who is auditing of loitering. If you are in a publicly accessible place that does not have posted no trespassing or restricted access signs, and all you are doing is photographing or filming, regardless of the time, then there is no justifiable concern for the safety of the public or property in the vicinity. It is still advised to ensure you seek legal counsel if you are being accused of loitering in a public place. Section 2. Among the circumstances which may be considered in determining whether such alarm or immediate concern is warranted is the fact that the person takes flight upon appearance of a law enforcement officer, refuses to identify himself or herself, or manifestly endeavors to conceal himself or herself or any object. Unless flight by the person or other circumstance makes it impracticable, a law enforcement officer shall, prior to any arrest for an offense under this section, afford the person an opportunity to dispel any alarm or immediate concern which would otherwise be warranted by requesting the person to identify himself or herself and explain his or her presence and conduct. No person shall be convicted of an offense under this section if the law enforcement officer did not comply with this procedure, or if it appears at trial that the explanation given by the person is true and, if believed by the officer at the time, would have dispelled the alarm or immediate concern. Now, obviously, it wouldn't be wise to full-on sprint away from an area if police arrive, but if you are 100% certain that you are not committing any criminal infractions, you can calmly walk away from them. If law enforcement attempts to stop you, it is suggested to always ask, "Am I being detained or am I free to go?" If they say you are free to go, it is easiest to just leave the area and break off communication. If they state that you are being detained and say something along the lines of, quote, "We're just trying to figure out what you're doing," or completely avoid the question, you have the opportunity to state, "I am a photographer conducting lawful First Amendment protected activities," or "I am an independent journalist documenting matters of interest of the general public," which is enough to dispel any alarm or immediate concern. If they still won't release you from your temporary detainment, it is wise to either invoke your Fifth Amendment right by stating, "I will be invoking my Fifth Amendment right to remain silent, and I will not be answering any more of your questions," or continuously asking if you are free to leave. This section offers you protection in court if an officer arrests you or illegally detains you for longer than a reasonable amount of time to determine if your activity is lawful or not. Section 3. Any person violating the provisions of this section shall be guilty of a misdemeanor of the second degree, punishable as provided in Statute 775.082 or Statute 775.083. In some instances, you may come across a scenario where a public official or a law enforcement officer tells you you cannot record them, or that by recording them you will be in violation of the Florida wiretapping laws. This has been proven to not be true when the 11th Circuit Court of Appeals made the decision on the case of Smith v. City of Cummings, that it is a First Amendment right to photograph or videotape police conduct. This decision also held true to photographing and videotaping of public officials. The court stated that the First Amendment protects the right to gather information about what public officials do on public property, and specifically a right to record matters of public interest. This was also held as the ruling in in many notable Supreme Court rulings, such as Fordyce v. City of Seattle, Ikobuchi v. Bolter, Blackston v. Alabama, United States v. Hastings, Nixon v. Warner Communications, Thompson v. City of Clio, and many others. There are, however, limits to when you can and cannot videotape or photograph in certain public buildings. For instance, if you are allowed the ability to enter into a restricted access area with permission, you may not be allowed to record in the restricted area. The Florida Sunshine Manual provides great insight into the restrictions of photography and recording, as well as what areas are considered off-limits. A link to the Florida Sunshine Manual is available on our website at SWFLOAP under the First Amendment Audit page. You may also encounter accusations that you are filming a federal facility and that you need to stop. This is far from the truth. The Department of Homeland Security Federal Protective Services released a revised memo on March 30th of 2018 titled Operational Readiness Order HQ-ORO-002-2018, which gives notice that there are no laws prohibiting the photography of federal and government buildings and installations. They even make mention that case law supports the protection of the First Amendment right to do this. The memo even states that public safety officers are not to adversely impact the public's right to photograph and videotape. This includes federally owned or leased buildings, and that 41 CFR 102-74.420 does not prohibit photography by individuals of the exterior of these facilities, but does give guidelines on what and when an individual may photograph the interior of these buildings, including the space occupied by the tenant agency, building entrances, lobbies, foyers, corridors, or auditoriums. This also includes the ability to record through a window of a restricted access area, provided you are not in the restricted access area, or blocking the movement of an authorized person from entering or exiting the area. You can also record through both interior and exterior office windows or transparent booths. They also define that certain commercial photography and videography can require written permission or written authorization, but that journalists, news media, or individuals recording for news purposes are not considered commercial photography. They do state that individuals who are recording cannot disrupt the performance of official duties nor prevent the public from attaining government services. However, the act of photography or video recording itself cannot be the sole reason of obstruction. If for any reason your civil rights have been violated while auditing, there are two U.S. Title Codes that offer protection and legal recourse. Under U.S. Title Code 18, Crimes and Criminal Procedures, Chapter 13 discusses civil rights. Section 241, Conspiracy Against Rights. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, or if two or more persons go in disguise on the highway or on the premise of another with intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured, they shall be fined under this title or imprisoned not more than 10 years or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, they shall be fined under this title or imprisoned for any term of years or for life or both, or may be sentenced to death. Section 242. Deprivation of rights under color of law. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such person being an alien or by reason of his color or race than are prescribed for the punishment of citizens, shall be fined under this title or imprisoned not more than 1 year or both. And if bodily injury results from the acts committed in violation of this section, or if such actions include the use, attempted use, or threatened use of a dangerous weapon, explosives, or fire, shall be fined under this title or imprisoned not more than 10 years or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, shall be fined under this section, title, or imprisoned for any term of years or for life or both, or may be sentenced to death. If you feel that your civil rights have been violated under either of these title codes, it is strongly advised that you seek legal counsel. I hope this educational video has helped you become a bit more familiar with specific Florida statutes and Supreme Court rulings that protect your civil rights while auditing. I encourage you to join the cause and to record any and all interactions with government officials whenever possible. You never know when your recording may help someone or yourself when facing a legal predicament. As I've stated before, this video is for general knowledge and is not to be taken as legal advice. I appreciate your time in allowing us the ability to share this information with you, and I'm looking forward to seeing the rise in numbers of those willing to stand up for our civil rights. This is James with Southwest Florida Oath Accountability. Stay safe, stay vigilant, stay educated on the law, and never stop recording.